So welcome everyone to this second seminar in the series on the United Nations Convention on the Rights of Persons with Disabilities. Today's theme is getting justice in the context of the UN Convention. My name's Gemma Neville. I work at the Scottish Human Rights Commission, and all these seminars are jointly hosted by the Scottish Human Rights Commission and the Equality and Human Rights Commission. And I'm joined today by my colleague Laura Hutchison from the Equality and Human Rights Commission and our guest speaker Lindsay Reynolds from the Legal Services Agency. And I'll hand over to them in just a moment. We had our first seminar in December, and a recording of that live event is now available to view on the Scottish Human Rights Commission website. So if you weren't able to join us at the time, please go back and have a look or listen at your own time. So a wee bit about how today's going to work. Please do introduce yourself in the text box, as many of you have done so already. And it's great to see lots of international interest from as far afield as Afghanistan, Finland, Romania. That's really fantastic. Although today's event really is aimed at disabled people's organisations and disabled people here in Glasgow. But everyone is very welcome. So do introduce yourself, say hello, and as always, ask questions and make your own comments, share your experiences in that text box. The theme is getting justice, and today we'll not be able to cover individual legal complaints, so very much looking at systematic issues in regards to access to justice. And our guest speaker today will touch on the barriers, attitudinal, societal, structural barriers that remain for the state to get rid of these barriers so that disabled people can enjoy full access to their rights here in Scotland. So we'll go on to that later in the seminar. If you want to tweet about the event, you can do so with the hashtag CRPD seminar. Also, there will be live palantyping. Thanks very much to our palantypists, and you should be able to see that scrolling along the foot of your screen. So I think that's enough for me for just now. I'll come back at the end to wrap up and to explain more about how you can continue to engage with our work on promoting the UN Convention on the Rights of Persons with Disabilities. But over now to my colleague Laura Hutchison from the EHRC. Thank you.
Hi, thanks very much Gemma, and thanks to everybody who is joining us online, and to Lindsay for joining us to speak today about access to justice and some of the barriers in the legal system in Scotland. What I would like to do for the next 5 minutes or so is to really just give a very brief overview of the convention. If you joined the seminar, the last seminar that we did in January, Duncan gave a very full explanation of the convention and the purpose and how the convention works. I don't want to go into that much detail. If people would like that detail, they can re-watch the seminar from January by going to our websites. But what I would quite like to do is just to kind of go through the kind of main areas of the convention, to explain why we chose getting justice as the theme for this second seminar, and to outline some of the main articles in the convention in relation to this topic, and then I'll pass on to Lindsay. Next slide please. So touching on first the convention, as I'm sure all of you joining us will be aware, the Disability Convention is an international human rights agreement. Perfect. Is an international human rights agreement, and it was signed or ratified by the UK government. The purpose of the convention is to recognise that disabled people continue to face barriers to equal participation, to equality, they still face discrimination and violations to their human rights, and to oblige governments and public bodies to take action and to take steps to recognise disabled people's equal human rights with others. It also displays a commitment by governments to ensure that disabled people will enjoy the same human rights as everyone else without discrimination. Next slide. And so what's the Commission's role? Well, the Commissions are the independent mechanisms established under the Convention. In the UK, that's the Equality and Human Rights Commission, the Scottish Human Rights Commission, the Equality and Human Rights Commissions in Northern Ireland as well. So there's 4 bodies who are the independent mechanisms for the UK. As well as having these specific roles to promote, protect and monitor the implementation of the Convention, what the Commissions are now starting to do, as the Convention has been in place for several years, is we are now incorporating our work on the Convention into our day-to-day work and business plans. The central thing about the Convention is disabled people. Nothing about us without us is one of the key concepts behind the Convention, and is integral to proper and full implementation. And what we encourage the use of the Convention is to achieve social change in the UK. So it's not just about legal action, it's about using it as a tool to address issues and areas of inequality or breaches of human rights. Next slide, please. So, why did we choose access to justice? Well, some of you will be aware from previous participation with us. For the past 2 years, we've been promoting implementation of the Convention and asking disabled people to tell us what they feel are the outstanding issues that where more needs to be done, where there are infringements to people's human rights and where there is great inequality. And one of the themes that came through from those events was accessing and getting justice. And during our participation events, what disabled people have told us, I'll just run through some of the key points in relation to this topic, is that they were afraid of reporting incidents of harassment and bullying to the police, that they had limited confidence in the criminal justice system's ability to protect them. They felt that police could be less likely to accept that a crime had been committed if it was reported by someone who had a learning disability, so issues to do with perceived credibility, perhaps. Learning disabled people also told us they were concerned about using and accessing the court system. All disabled people that we spoke to reported that they found it hard to navigate the legal system in Scotland, so that could be accessing solicitors, interactions with the police as well as with the court system. There was also a fear that disabled people would not be provided with the opportunity to speak for themselves, to have their own voices heard and respected and listened to. And there was also finally reported that it was difficult to access specialist legal advice and representation, particularly in some of the remoter parts of Scotland. So I'll now just turn to the Convention itself and what the Convention requires of the government, of state parties is how it's referred to. Article 4 sets out that government should not act in any way that is inconsistent with what is set down in the Convention. They should proactively introduce appropriate laws and other measures to see the Convention implemented. They should take all appropriate steps to change, abolish existing discriminatory laws, policies and practice. And on a day-to-day basis, they should be taking into account the Convention in their policies and practices and any project or programme work. And finally, very importantly, the state has a responsibility to promote the Convention with public authorities to ensure that they also comply with the obligations and the positive duties that are set out in the Convention. In relation specifically to today's topic, just to draw your attention to some of the articles that relate to accessing and getting justice. Article 12 of the Convention talks about the right of disabled people to make their own decisions, and the right to legal capacity in their own name. Disabled people cannot be denied the right to make their own decisions by the state, and if they require help in order to make their own decisions, government should put in place steps and measures that will provide that help and support to disabled people. In certain circumstances, people do need someone else to speak on their behalf, and that's recognised as something that does have to happen. But what the government should be doing is putting in place effective safeguards to make sure that the rights of disabled people and their interests are protected, and that there's no abuse of that position of speaking on somebody else's behalf. Article 13 looks at the right to access and participation in the justice system. So disabled peoples have the exact same rights as other people to take legal action, to act as a witness in court proceedings, and to take part in court action the same as anyone else. So for instance, to be a member on a jury. Again, similar with Article 12, the government must provide support, and the court service and the police must provide support if needed. So for instance, you can see this by the reasonable adjustment duties that are required under the equalities legislation. These bodies, courts and the police, must make reasonable adjustments to ensure that disabled people can participate. The Article 13 also sets out that the state should ensure and promote appropriate training for staff in these organisations to make sure that the right to access and participate in the justice system is upheld. Article 14 of the Convention talks about the right to liberty and security. Nobody should be deprived of their freedom and their liberty because they are disabled. If an individual is detained, and people can be detained because they've committed a criminal offence that holds a criminal sentence, or if they're detained under mental health legislation, the Convention sets out very clearly that certain conditions must be met, reasonable adjustments must be made, and safeguards must be put in place to ensure individuals' human rights are protected. Articles 15 and 16 of the Convention talk about protection from degrading treatment and exploitation, violence and abuse. So by degrading treatment and exploitation, we mean that treatment that causes severe mental or physical harm, or that is grossly humiliating and undignified. The government must ensure that there's strong laws in place to make sure any cases of this sort of treatment are investigated thoroughly and prosecuted. And they also have a duty to ensure that disabled people themselves can recognise this kind of treatment and report any violence and abuse. And the public, what's one of the key things with these articles is that public bodies have a duty to protect and prevent this sort of treatment. They should also provide support to ensure the full recovery of the victims so that they regain back their control. And that's really where I want to leave touching on the Convention today, and would like to hand over to Lindsay from the LSA to talk through to you a bit about her work and some of the barriers to justice in Scotland and some of the key features of the legal system that may hopefully be of interest to you and to all of us. Thanks.
Thank you very much to Laura and to Gemma and to the Equality and Human Rights Commission and the Scottish Human Rights Commission for inviting me to speak to you today. I'm Lindsay Reynolds and I'm a solicitor at Legal Services Agency. Next slide, please. To get into practice. As you'll see from the next slide, I work in the Mental Health Legal Representation Project. We are a specialist project aiming to assist people with mental health problems, and we acknowledge that there are additional legal difficulties which are sometimes compounded by illness, and as a result, often people with disabilities do not get the legal help they need. We have a project in Glasgow which covers the Strathclyde area, and we also have a project here in Edinburgh which covers Edinburgh and the Lothians. You'll see on the slide there's a list of some of the areas of law which we deal with. Perhaps the majority of our work is in relation to the mental health legal representation under the Mental Health Act, as well as under the Adults in Capacity Scotland Act. However, we do offer, or we try to offer, a holistic service in relation to civil and administrative law. So you'll see a list of some of the other aspects of law which we're also able to assist with. We don't cover criminal work at all, which is really the only exception. Next slide, please. My aims for the talk this morning are to discuss some of the barriers which face disabled people in accessing justice. Obviously, my expertise is perhaps more in the area of mental illness. However, I will touch on some areas which will affect people with physical disability. I'd like to signpost some of the research which has been carried out in this area, which is very interesting and informative. I'll provide a very brief overview of the legal aid system. That would be a seminar in itself. I'll also focus on some particular areas of law and consider some examples of some very good practice which we do see in Scotland, and as well as trying to identify some perhaps potential gaps in our systems. There's a lot of information on my slides, so if you need to refer back to them in the short space of time we have this morning, I will not have the opportunity to cover everything which is on the slides. There's more information available. Next slide, please. Turning first of all to physical and practical barriers. This could equally affect someone with a physical disability as well as a mental disability. Physical barriers could be as straightforward as not being able to access premises such as courts or solicitors' offices to be able to meet with a legal representative. There could be additional practical barriers, however, such as lack of information provided in accessible format. If somebody doesn't know the legal issue arising, they wouldn't know to access help, let alone where to begin to access it. There could be travel problems. This may disproportionately affect disabled people who may benefit from perhaps a home visit or hospital visit, and that's something which Legal Services Agency is able to offer. But I'm particularly aware that in perhaps remote and rural areas it may be very difficult to find a solicitor prepared to offer a home or hospital visit. It's important to remember that in terms of the equalities legislation, a solicitor is a service provider providing service to the public, and as such is under an obligation to make reasonable adjustments to their service. So where there's a provision, criterion or practice or physical feature which might put a disabled person at a substantial disadvantage compared with those who are not disabled, the service provider is under a duty to make reasonable adjustments to that service. This can also apply to the provision of auxiliary aids, where not providing them would place a disabled person at a substantial disadvantage. This is a very complex area of law in relation to what's a reasonable adjustment, and if you'd like more information, the Equality and Human Rights Commission's website is referred to there, and it's very informative and contains information about codes of practice, for example. Next slide, please. Perhaps harder to define and perhaps more subtle is attitudinal barriers. This might be an overall perception, which is something which is quite difficult to put your finger on. There's been some research done in this area, such as the Justice Disability Steering Group, which is a multi-agency group. They've stated that they're keen to develop ways in which disabled people can be involved in helping to improve access to services across the justice system in Scotland. They produced a report in 2009 alongside Capability Scotland, and one of their conclusions was the justice sector organisations should provide mental health awareness training to staff. Testimonials within a supported training environment from staff who've had personal experience of mental ill health can be very powerful in terms of challenging attitudinal barriers. So they're perhaps recommending more training for the legal profession. Next slide, please. Another interesting survey which was carried out in 2011, this was a joint project of the University of Stirling and Equal Say Advocacy. Kay Goodall and Julian McIntyre were the authors of the report entitled A Fair Say. It's referred to on my slide. They did a sample of 26 interviews of people with learning disabilities about accessing justice, and they mentioned barriers including assumptions being made that people with learning disabilities lack capacity and therefore cannot instruct a solicitor. And it's important for us all to remember that there's a presumption of capacity. There's always a presumption that a person can instruct a solicitor unless there's evidence to the contrary. The report also suggests there's a lack of knowledge and specialist training about the issues faced by people with learning disabilities, so that's perhaps something which could be addressed amongst the profession. Next slide, please. As with accessing justice for anybody, financial barriers are important. As I've mentioned, the legal aid system is complex, and if you do have a question about legal aid, I'd advise you to approach the Law Society, who can give you a list of a legal aid solicitor, or you can have a look at the Legal Aid Board's own website, which has their handbook available online. It's a very informative document. In general terms, in relation to civil law, which is what I largely deal with, you've got advice and assistance, which covers office-based work such as meeting with a client, providing basic advice, corresponding. It doesn't cover going to court. If you want to go to court, you need to apply for civil legal aid. There is a form of advice and assistance called advice by way of representation, which authorises a solicitor to attend a tribunal situation on your behalf. So employment tribunals, for example, mental health tribunals are covered by advice by way of representation. You might hear this referred to as ABWAR. There's also children's legal aid, which, although the title suggests only available for children, it's also available for parents and relevant persons in relation to children's legal aid issues. With all these types of legal aids, some of them are means tested, so you have to be financially eligible. Not all of them, surprisingly. Some are merits tested, which means you've got to demonstrate probable cause or reasonableness to the Legal Aid Board, and some of these are both. As I say, it's very complicated, but there's reference there to the Legal Aid Board's website. Next slide, please. It's important to note that there are changes ahead. We're in a time of economic downturn, and the Legal Aid Board is under pressure as any public body. The legal aid reforms I've referred to there, the Scottish Government's strategic spending review agreed an overall settlement which represents a cut of 7.17% to legal aid and 9.3% cut to administrative costs within the board. If you're interested in more information about this, you can see the white paper on a sustainable future for legal aid. You could also have a look at the Legal Aid and Scottish Civil Justice Council Scotland Bill, which is to be introduced to Parliament in May 2012. If there are concerns about how these changes may impact, particularly in relation to disabled people, you might want to have a look at the Scottish Government Equality Statement. I've put a link on there. One issue which occurred to me, for example, is that an aspect of what is being proposed and has already taken effect, in fact, is cutting the allocation of funds to solicitors for travelling to meet with clients. So if you're relying on a solicitor coming to meet with you at your home or at a hospital, it may well be more difficult to persuade a solicitor to do that, as the funding has been cut for that aspect of legal work, and that could have an impact on disabled people. Next slide, please. It's often said in human rights discourse that for rights to work, they have to be practical and effective, not just theoretical and illusory. So I think it's important to focus on some different areas of legal work in Scotland. As I've mentioned, I don't work in the criminal justice system, but I'm aware from what Laura has said this morning from the work of the Commission that is an area of concern for disabled people in terms of reporting crimes and being taken seriously and pursuing a prosecution, for example. So the next slide, please, identifies and highlights again, so I think we need to go back a slide to the criminal justice system. We've skipped one. Can we go back to the previous slide? It's on the, I think we've skipped on the criminal justice system. It should be reporting a crime. That's it, thank you very much. I've emphasised again, because it is important to emphasise, that there's a presumption of capacity. So there's a presumption that a victim of crime can report the crime and can be a witness. Where somebody maybe needs a little bit more support, there is an appropriate adult scheme, and there's a link there to the Scottish Government website, information about that. The aim of the appropriate adult scheme is to acknowledge that the presence of an appropriate adult is about trying to ensure equality for the person being interviewed. It's not about advocacy or speaking on behalf of a person with a mental disorder. Rather, it's about an independent third party checking that effective communication is taking place and that the person being interviewed is not disadvantaged in any way due to their mental disorder. Next slide, please. And there's a slide there referring to the service available from witness and victim support, who can provide confidential, emotional and practical assistance in relation to the criminal justice system and attending court as a witness. Next slide, please. For both witnesses in civil and criminal matters, there's the Vulnerable Witnesses Scotland Act 2004. There are provisions relating to children, but my area of interest relates to the provisions relating to adults, so that an adult giving evidence at a criminal trial or a civil hearing can be deemed to be a vulnerable witness, and having that status means that they're entitled to have special measures in place to assist them to give their evidence. Special measures can include evidence by way of a commissioner, which is someone taking the evidence from you and speaking to you about it, perhaps in your own home. It could be a live TV link. It could be giving evidence behind a screen, so you're not having to face perhaps the perpetrator of the crime. It could be by bringing a supporter along with you. Again, the supporter can't speak on your behalf, but can be there to give you some support throughout the process. Or you could give a prior statement, and it might be possible to have affidavits agreed in advance rather than having to go along and give your statement to the court. In order to be deemed a vulnerable witness, factors to be taken into account are whether or not the person has a mental disorder, or there could be fear or distress in connection with giving evidence, and a range of circumstances will be taken into account, and that includes physical disability or mental impairment, and those can be taken into account in assessing someone's status as a vulnerable witness. It also flags up to the sheriff or whoever's deciding the case that this person needs some additional support in giving their evidence. Next slide, please. Laura has helpfully covered Article 12 of the Convention, so I won't go into it in too much detail, but the slide there gives a little bit more information about what Article 12 entails. It's important to distinguish between supported decision-making and substituted decision-making. Supported decision-making is where the state ensures that there's sufficient support put in place to assist somebody. That could be by way of advocacy services. And that helps somebody to make the decision for themselves. Whereas substitute decision making is where somebody lacks the capacity to make the decision for themselves, an appropriate person has to be put in place to make that decision on their behalf. And if a substitute decision maker is put in place, there have to be legal safeguards to ensure that the will and preferences of the person are respected. It must be free of conflict of interest and undue influence. It must be tailored to the individual, and it must apply for the shortest period of time. And we'll come on and talk about adults in capacity proceedings where this is very important, increasingly so. Next slide, please. In relation to civil matters, the issue of capacity and time bar can present additional hurdles. There's, once again, always a presumption of capacity to instruct. Where a person doesn't have capacity to instruct and there's a legal case to be taken, the court can appoint a curator ad litem, who's usually a solicitor, who will act on behalf of the adult. The sheriff court or the court can obviously only put in place a curator ad litem where there are legal proceedings already raised, and there may be difficulties in actually getting legal proceedings to the point of court. And under those circumstances, it may be necessary to have a guardian or an intervener under the Adults in Capacity Scotland Act appointed beforehand, so that person can raise proceedings on behalf of the adult. Time bars can be challenging for anyone in accessing their legal rights. If your case relates to a personal injury, you've got 3 years to raise it. If it's more of a financial matter, there's 5 years. And if it relates to discrimination, you've got 6 months to raise your case. And during that time, you need to instruct a solicitor, get proper advice, perhaps apply for legal aid, fully investigate your case. So this can be challenging for anybody. So it's important to note that the Prescription Limitations Scotland Act 1973 authorises periods of time to be disregarded when calculating the time bar. And we'll see an example of some excellent 1970s drafting, as you'll see that where someone has a disability for reason of unsoundness of mind, which is not a term that we'd use any longer, but which still applies and can help time bars to be extended. Next slide, please. In relation to claims for perhaps disability discrimination or other forms of discrimination, first of all, you've got to contend with a 6-month time bar. But an additional issue is that often your remedy is in fact the declarator. What you're really looking for is public acknowledgement that your rights are being violated, and it's very hard to put a price on that. And often the quantum, as we refer to, or the money you'd expect to receive by way of compensation can be quite low. Where it's less than £3,000, this is classed as a small claim, and the small claims procedures in our Sheriff's Court are deemed to be suitable for a party litigant or someone who's not represented. As such, it can be very difficult to persuade the Legal Aid Board to fund this, and you wouldn't ordinarily expect to get legal aid for a small claim. Even if your claim is in excess of £3,000, where the quantum is relatively low, but the cost of the case can be quite expensive. You might have to get expert reports, expert witnesses solicitors and advocates involved, and the costs can be quite extreme, the legal aid board will balance the amount of money that you're likely to get at the end of the day against the cost of running your case, and that's a factor which can be taken into account by the legal aid board when considering whether or not it's reasonable to grant legal aid. Next slide, please. On a perhaps a more positive note, the Mental Health Care and Treatment Scotland Act 2003 brought into play the Mental Health Tribunal, which is an area of law which my department, or all of us at Legal Services Agency, are regularly involved in. And it's interesting to note the Justice Disability Steering Group report stated that the Mental Health Tribunal demonstrates a good level of understanding of disabled people's needs, and so can perhaps be taken as an example of some positive work being done in this area. The Section 1 principles, for example, require those discharging a function to have regard to the patient's wishes. The patient has always got a right to independent advocacy. They have a right to have a named person, whereas previously it falls to your nearest relative. It's not often necessarily your nearest relative. You can nominate somebody who's got the right to attend the tribunal, they've got the right to receive papers, and also to apply for legal aid. In relation to legal aid, non-means tested ABWOR, we mentioned ABWOR earlier, so that's a solicitor who can come along and represent you at the tribunal on a non-means tested basis, and that's available both to the patient as well as to their named person. I've put some cases in there which have thrown some issues to the fore in relation to representation. In the case of Byrne against the Mental Health Tribunal, this was a very early case at the start of the procedures before the Mental Health Tribunal, where it was established that it's not sufficient just a representation, that representation has to be effective. So this was a case in which Ms Byrne's solicitor had only had very little notice of the hearing, and only met with Ms Byrne a couple of hours before the tribunal that day, and her request for an adjournment was refused. This was overturned on appeal by the Sheriff Principal, who stated that representation, to be compliant with various human rights instruments, has to be effective, and the patient has to have time to consult with their solicitor, perhaps instruct a report, and to fully prepare the case. Where a patient within the tribunal system doesn't have capacity to instruct a solicitor, the Mental Health Tribunal themselves will appoint a curator ad litem, and many of us at Legal Services Agency act as curator ad litem. That's where a solicitor is appointed to act to safeguard the interests of a patient within the system who doesn't have capacity to instruct their own representatives. So it's a very important role. It's been established, however, that the curator ad litem, unlike the solicitor for the patient, that's the light sound, doesn't have the statutory right to appeal to the Sheriff Principal. So whilst the solicitor representing the patient or the named person could, the curator ad litem cannot, and I've put the reference to the case there. Next slide, please. In relation to Adults in Capacity Scotland Act, we've mentioned that a little bit earlier on. If somebody doesn't have capacity to make decisions in relation to their own welfare or their finances, or indeed it could be to take forward a legal challenge, then somebody could be appointed to act as guardian to them or intervener under the Act. Similar to the Mental Health Tribunal system, under the Act, the Sheriff has to take account of the present and past wishes of the adult. They've also got to take account of the wishes insofar as expressed by an advocacy worker, so you've got a statutory role for the advocacy worker there. The application will ordinarily be intimated or served upon the adult, so if there's proceedings being taken about you, you should receive a copy of the papers, unless it can be established that to do so would pose a serious risk to your health. So it's not enough to say that the adult will be distressed or upset or confused by the papers. You'd have to actually establish on the basis of 2 medical reports that it would pose a risk to the adult's health before the intimation can be dispensed with. So the adult's entitled to attend court to instruct a solicitor, and there's a statutory obligation on the Sheriff to consider whether or not to appoint a safeguarder, which operates similar to a curator ad litem, although it's worth pointing out the safeguarder is not always a solicitor, it's not always someone who's legally qualified. It could be perhaps someone from a social work background if appropriate. I mentioned Article 12 of the Convention, which means that any substitute decision making such as this has to be kept under review and be for the shortest period of time. So increasingly sheriffs are appointing shorter orders, perhaps of 2 or 3 years, and will be kept under review. It's also worth noting that there was a bit of confusion and concern about the rules in relation to renewal of guardianship orders, whereby when an application was made to renew the guardianship, it had to be served upon the local authority and the Mental Welfare Commission, but not the adult who's at the heart of the proceedings. And I understand the Equality and Human Rights Commission have done some work with the Rules Council to try to address this, and it's really good practice. I think most sheriffs would agree to serve a copy of the application for the renewal upon the person who's at the centre of the proceedings. Again, in relation to legal aid, might surprise some of you to hear that civil legal aid for guardianship matters is non-means tested as long as there's a welfare component, so either for welfare, guardianship, or welfare and financial guardianship. There's advice and assistance available to provide basic advice, and that is means tested, but it's based on the adult's resources. So if you're considering applying for guardianship, your finances will be disregarded and the legal aid will be looked at in terms of the adult's resources. Now, I'm conscious of time here. The next slide, are we okay for time? If we skip to the next slide, please, which covers criminal injuries compensation scheme. Whilst I mentioned that Legal Services Agency doesn't involve itself with the criminal justice system, we are able to assist with criminal injuries compensation, which is a scheme which aims to compensate victims of crime. There is advice and assistance available, but it's not at war, which means that you're not covered for representation at the tribunal. However, you might find a law centre may be prepared to represent you in any event. If you are granted advice and assistance, it's also important to remember that any award you ultimately get from criminal injuries compensation scheme would be subject to clawback, and that means that your legal expenses would be deducted from your award unless you can demonstrate sufficient evidence for a hardship application. You can get more information about that from the Legal Aid Board or from a solicitor. We spoke about time bar earlier. For criminal injuries compensation applications, the time bar is 2 years. However, it can be waived in particular circumstances where it's practical for the application to be considered and where it would not have been reasonable to expect the applicant to have made an application within the 2-year period. And I would expect that if you have evidence of a disability which has affected your ability to seek advice to make the application, that would be strong evidence in support of extending the time limit for you. However, it's important, the importance of reporting crimes and complying with the police is exemplified within the scheme, because paragraph 13 requires you to report this to the police, and any failure to do so or to failure to cooperate with the police or any other authority in bringing the assailant to justice can be taken into account, and your reward could be refused or reduced. Next slide, please. The Employment Tribunal, again ABOR, which provides advice and representation, may be available, not in all circumstances, but one of the factors the Legal Aid Board takes into account when assessing this is that the applicant may be unable to understand the proceedings or to state their own case because of their age, inadequate knowledge of English, mental illness, or other mental or physical disability or otherwise. So whether or not your impairment relates to mental health or a physical disability, that could persuade the Legal Aid Board to make ABOR available for a solicitor to represent you. I spoke a little bit in the previous slide about clawback, and again, clawback applies to ABOR for employment tribunals. This hasn't always been the case. This was a change of policy as of 1st April 2011. The regulations changed there. Time bar is quite restrictive for employment tribunal matters. It's usually 3 months less a day, unless you can persuade the tribunal that there's special circumstances. Next slide, please. The final area of law I want to look at today is children's hearings. Children's hearing system is in a bit of a state of flux, and at Legal Services Agency we ordinarily represent relevant persons who's often the parent of the child under consideration. The relevant person is able to access children's legal aid subject to a means test at sheriff court level. So if the referral is passed to the sheriff court, or if you're appealing against the decision of the children's hearing to the sheriff, you can apply for civil legal aid, and as long as you qualify financially, that would ordinarily be granted. At present, it's the sheriff that makes that decision. However, that role is being transferred back to the Legal Aid Board under new rules. In terms of the hearing itself, however, you might find that the children's hearing is making significant decisions such as where a child is to reside, or the level of contact between a child and their parent or grandparents or relevant person. This is a significant decision relating to family life, and yet there's not legal aid available for that stage of the process. This has been addressed in various cases at Court of Session level, and an interim scheme has been put in place whereby at a business meeting the children's hearing can appoint a legal representative. I understand that there are some concerns about this, as often the legal representative is given very little notice of the case and may often meet with the relevant person on the day of the hearing and may not have a full understanding of the background. In addition, I'm not aware of any funding available to them to instruct reports if they have additional concerns. So there are some concerns in relation to the system as it currently operates, and this system is undergoing some significant change. You'll see I've made a reference there to the Children's Hearing Scotland Act 2011. And then there's changes to legal aid provision which are not yet in force. There's also a very recent case of EM against the Scottish Legal Aid Board at the Court of Session in 2011, which dealt with the availability of funding to cover the cost of reports if the relevant person, for example, wishes to obtain an independent report if they don't agree with social work's recommendations. I'm not clear how Legal Aid Board is going to implement that decision or whether or not it will be further appealed, so I won't say too much more about that, but it's really just important to note that there are issues affecting legal aid provision in this area and that there are changes coming. And next slide, please. This is my final slide, and it's really just to make some references there to the Law Society, to Legal Aid Board, the Scottish Independent Advocacy Alliance, and also suggest that there might be a law centre available in your area who might be able to assist with some of the issues that I've raised today. And I'd just like to say a final thank you to both commissions for inviting me today, and I think we're going to deal with some questions now.
Okay, well, we have been passed some questions and some comments that people joining us online have put to us and for general comment. So I think the kind of first question that came out, and this will be the first you're hearing of it, Lindsay, is in relation to Article 13 about accessing or equal access to justice and participation in the justice system. The question relates to disabled people being excluded from jury service because of their requirement or their need for interpretation services. It's saying here only those appointed to jury can be in the final closed session, and this may lead to the exclusion of interpreters, carers, etc. Also raising concern about if there is visual evidence, and that excludes people with visual impairments. And that's from Morag Redwood at SCVO Inverness. And she's asking, is there anything that can be done about this? I understand that Duncan has answered to some of that online. I don't know if Lindsay has anything more to add. I would emphasise that Article 13 in the Convention, and also in the duties that are placed on public authorities in the Equality Act to make reasonable adjustments, means that these public bodies should be taking all reasonable steps to make sure that disabled people can participate, and if there is any instances or evidence of people being excluded, the commissions both would be interested from our role as monitoring the implementation of the Convention, so that we can raise any concerns with government, but also it may be that the Equality and Human Rights Commission may want to look into that in terms of whether we could provide any assistance to any individuals. So we would like to be made aware of any of those instances, if people are aware of that happening. Lindsay, you also mentioned the Justice Disability Steering Group.
Yes, that's right. And
it may be that this is an issue that should go to that steering group. I'm not aware of how often they meet or how regularly they meet, but to draw their attention to concerns about the exclusion of disabled people from jury service.
I think it's a very interesting point, and whilst it's not something that has ever been directly raised with us, I do think it seems to be contrary to the ethos of a jury, which is to try to get a broad spectrum of the population in deciding in criminal matters. And I certainly think that's something which could perhaps be raised with the Justice and Disability Steering Group as suggested.
There have been also, there's been a comment about lack of funding for advocacy services, and yes, that is a concern, and I think that is something that the commissions as well and disabled people have a role in monitoring how decisions to stop funding or to limit funding in these areas are having an impact in practice, and that's something that we should all be monitoring and asking government as well to monitor the impact of their decisions to limit funding on on the impact of that on disabled people, and to take steps to minimise any negative impact that is there. Do you have anything on advocacy?
Just to comment that there is a statutory obligation under the Act to provide advocacy services, and to make funding available so that we can run those services. I am aware that it's advocacy funding, like most public funding at the moment, is in a bit of a state of flux.
Another question that has come in is about whether the panel has any thoughts about cuts to funding for advice centres. And given that you work for an advice centre, Lindsay, you may have a specific interest in this.
I think, given that I work in a law centre, it's probably better for me not to comment on that, but thank you for thinking of us.
I think it is important in relation to the cuts to funding that that the convention does place an obligation on the government not to take any negative steps, not to go back a step from where we are, so that the government, if there are changes to the funding situation in terms of law centres and advice centres, then that they monitor that impact, as we were saying, for advocacy, but also that if there is any negative movement in terms of people's access to justice in Scotland, that is flagged up with the Scottish Government, and steps are taken to redress that, because that is directly against what the convention is setting out. It's perhaps also worth mentioning that, sorry, it's bits of paper. It's also worth mentioning the Scottish Independent Advocacy Agency, Alliance, SIAA, recently, I think last week, produced a report on cuts and funding to advocacy. It was launched last week and is available on their website, and certainly that's something that we'll be including with our body of evidence, looking at how the impact of cuts on disabled people and services, and the ability of the Scottish Government to implement the convention at the same time as these cuts are coming into place. Just reading through. One thing that hasn't been mentioned, but I might take the opportunity to mention it, it's in relation to employment tribunals. I don't know if people are aware, but there has been from the UK government a review of the employment tribunal service and proposals on changes, quite significant changes to employment tribunals, including in some cases the proposal that people would have to set down some money if they were taking a case, and making it, what appears to many of us, making it harder for people to take a claim to an employment tribunal. And one of the benefits of the employment tribunal, unlike the way in which the court system operates, is that the tribunal is much more user friendly. You can go and represent yourself, or you can have somebody represent you who's not a solicitor, and it's meant to be less adversarial in the terms that the court system is. And so the Commission certainly are keeping a close watching eye on what the government actually introduces in terms of changes to the employment tribunals, and will be making very strong representations that there is active monitoring of how that impacts on disabled people and other equality groups, and their right to access equal access to justice, and to really see what the effect of changes to the employment tribunal proceedings is or are. Do you have anything on the employment tribunal? I know you
only that placing money is currently possible under the current system, but it's very unusual, and it tends to only happen where the case is deemed to be frivolous or vexatious. or where there's a concern that case is particularly weak, then one of the parties could be asked to place some money with the tribunal. But I think I read somewhere that it's only about 1% of cases that actually happens at the moment. It's very unusual, and it'd be interesting to see what criteria, or perhaps they're looking at extending the criteria, how we decide when that's appropriate.
Is there any more questions that are coming through from? Another thing maybe to mention to people who are joining online, I'm not sure how many people are aware of it, but the Equality and Human Rights Commission just now runs a helpline. That's part of our functions that are set down by the UK government that we have to do, and there has been a proposed change to the operation of the helpline, in that the Commission will no longer be running the helpline as of sometime in 2012. The UK government has launched or put out a tender to external organisations to bid to run the helpline. So it's an added period of uncertainty in terms of access to advice. While we'll still have the Commission will still have information available on its website, the provision of the helpline service, which is particularly popular with disabled people, we get a lot of calls from disabled people about their rights and equality issues. So I think that's one to watch and to see how that impacts, and hopefully whoever it is that does deliver the new helpline service will make sure that Scotland's well represented, and that people still have the level of access that they have just now, if not better access. So that's one to.
Fortunately, Legal Services Agency has our own advice line, which is available to anyone with a mental health issue or their carers. We can give verbal advice over the telephone in relation to a whole range of issues. It doesn't matter if you're not in the Glasgow area. We can give you some sort of basic legal advice over the telephone. The details of that are provided on one of my slides.
And I think I've just seen a question coming in, which is, are the UK government taking into account the differences between Scotland and England and Wales in their tender? So I presume that's for the this EHRC helpline. Yep. As far as I'm aware, they are. That certainly the Commission, and I understand the Scottish Human Rights Commission as well, were involved. Were consulted by the government about the tender and the process, and have fed in, because just now the Equality and Human Rights Commission has an agreement with the Scottish Human Rights Commission to provide advice on human rights, and the situation is very different in terms of human rights in Scotland, in terms of the Scottish Commission being in existence, and also the responsibilities of the devolved government, and so we're always making it very important that distinctions are made and the differences are recognised. Most of those differences are about whose responsibility it is to protect and promote equality and human rights, and making sure that people who are phoning in know where to go to either get further help, or who to go to in terms of trying to get the matter resolved that they're phoning about. But certainly we will be continuing to press very hard that those differences are taken into account, but I can't guarantee it because it's not within the Commission's control. Sorry, I'm just looking at another question. I'll just very quickly, while I'm waiting to kind of see what the final question is, I'll just very quickly cover a few things that the Scottish Human Rights Commission and the Equality and Human Rights Commission have been working on in relation to this subject and equality and human rights issues generally for disabled people. I'll just put a plug in for the Commission's, the Equality and Human Rights Commission's triennial review document, How Fair is Britain, and that has a lot of information and evidence about the issues that have been discussed today in terms of the state of play, if you like, for disabled people in Scotland and in Great Britain as a whole. So you can find some quite useful sources if you were looking for evidence to back up any concerns or individual complaints you might have. The Scottish Human Rights Commission, the Equality and Human Rights Commission have been encouraging the Scottish Government to develop an action plan that will set out steps that the Scottish Government will take to ensure the Convention is implemented in Scotland. And what we have been pressing for is that as part of developing that action plan, disabled people are involved in that process and have to be involved in that process if the Convention is to be implemented properly. And finally, just to draw attention to the Equality and Human Rights Commission harassment inquiry, which was published several months ago now, but in Scotland we are working on the follow-up work that is needed to address the recommendations that were in the harassment inquiry, and so people can find out more information on that. But we as a Commission are working with the Scottish Government and other bodies to ensure that recommendations stemming from that inquiry are taken forward. Three minutes.
Yeah, okay, well I think I'll just wrap up so that we do what we said we'd do and keep to 1 hour. And thank you very much, Laura, and thank you, Lindsay, as well. We've been once again incredibly lucky at having such an authoritative and knowledgeable speaker. There's a lot of detail in Lindsay's slides, so I'd encourage you to go back and look at them again, and we'll post them together with the recording of today on our website. So thank you for doing that. In an hour, we're always going to just touch on the issues and not be able to go into a lot of detail or to address individual concerns and complaints. Where you feel we've not been able to address your question or comment sufficiently, please do get in touch. You can contact us on hello@scottishhumanrights.com. And as I said online, it is worth remembering that the Scottish Human Rights Commission and the Equality and Human Rights Commission are independent national human rights institutions, so entirely independent of government and local authorities. Therefore, many of the questions that you raise are appropriate for government to answer and to address in their duty to remove barriers to the realisation of rights. So where we can, we will pass on your comments and questions to the appropriate leads there. Please continue to share your evidence and experiences, because it all helps for the commissions to build an evidence base in our independent monitoring role of how the Convention is being realised in Scotland. We have our next seminar coming up in a month's time, and contrary to what the slide says, it's on Monday the 13th of February, because we can't time travel, we'll be going forward in February, and the theme of that third seminar will be independent living and the UN Disability Convention. I'm delighted that our guest speaker at that seminar will be Pam Duncan from the Independent Living in Scotland project, so another great speaker. So now time for some thank yous. As I said again, we're really lucky having Lindsay from the Legal Services Agency with us today. And also behind the scenes, we've had Joe, Ken, Rennie from Video 3, our palantypists, and support from colleagues back in the office. And lastly, thank you to all of you for taking part, for giving up your time, bearing with any technical issues you might have been having. So please continue the dialogue offline, and look forward to seeing you in February.